All right. Good evening, everybody, and welcome to this meeting. With me is my longtime friend and colleague, Mr. Eric Delanenza. He specializes in insurance claim lawsuits, arbitration, and other sort of dispute resolution. He is also a member of the insurance committee of the New York County Bar Association. And Eric, why don't you and maybe a little bit introduction about myself if you have not met me yet. My name is Louis Liu, and I I am a corporate lawyer by background, but nowadays I'm hanging out a lot with Eric and do some insurance claim lawsuits, and I do a lot of EB5 lawsuits. And so that's a brief introduction about Eric and myself. So let's dive into the topic tonight, okay, which is the legal issues that I suppose most of you here are insurance brokers that you need to be aware of and watch out for in your day-to-day work. So now let me start share screen, and Eric will go through a presentation to share with you the actual substantive points of law. All right. Okay. You got to see my bill and all that. We lawyers are technologically challenged. You can tell I need to do this for Eric. All right, Eric, it's your floor now.
Okay. So, like Lou said, my our intent here is to review with you common legal issues that insurance brokers face. And so we're hopeful that this will be helpful to you to be aware of and educated about the legal issues that a broker can run into. It's also informative if you're an insurance customer as well. And insurance transactions go on every day, and there are many complex legal issues around them. And we sort of learn as we go. So we would like to here give you a good background knowledge of the issues of law that come up. So if you want to flip Lou to the next one. So, as we say in the first bullet point, even when brokers win lawsuits, you have to go through a lawsuit, and that involves stress, it involves time, and it also, as you probably know, impacts the future rates that you will get for your E&O insurance. Um, and on the topic of E&O insurance, whenever you believe there could be a claim, it's important to notify your carrier because insurance companies will not hesitate to claim late notice. That's one of the standard defenses that insurance companies use. So when you yourself feel like there might be a situation that could develop into a lawsuit, it's a good idea to err on the side of caution and inform your carrier and make sure you keep a record of doing that. Um, Next slide, Lou. And feel free to chime in as I go through this as well, Lou. Or if anyone has questions, feel free to ask.
Sure.
So, first of all, broker versus agent, we probably all know the distinction. A broker is independent, sells a number of different products for different companies. Agents typically work for one carrier. Like we'll see there's a State Farm agent, and these agents are probably advertised. I can't think of an exact advertisement here, but it's you see television advertisements for the State Farm agent or the Allstate agent or whoever it is. But when we say broker's dual role, we're referring to both broker and agent. Is that what is good for you is that the law considers you to be more or less like order takers and not fiduciaries. And I cite a New York Court of Appeals case that says insurance agents have a common law duty to obtain requested coverage for their clients within a reasonable time or inform the client of the inability to do so. However, they have no continuing duty to advise, guide, or direct a client to obtain additional coverage. So this is the first bullet point. And why? Because it's an important part of the law for agents and brokers to understand, which is that the law really only tasks you with the duty of getting insurance for someone that they have requested. And so that's what the order takers reference means. As far as courts are concerned, their focus on negligence is did you fill out or did you carry out that order correctly? And um, it is a somewhat limited view that, in full disclosure here, I sue insurance companies and from time to time agents and brokers on behalf of individuals and companies who have been denied insurance claims. And so this is a more narrow view than plaintiff lawyers like myself would like to see. Um, and it also, as the decision notes, is more restricted in the sense that it says an agent has no continuing duty to advise, guide, or direct a client to obtain additional coverage. And we all know, and I'm sure you've experienced on a practical day-to-day basis, clients come back to you and they ask you questions about what coverage they should have and if they should change their coverage or if they should increase their limits. And the law does not say that you have to engage with clients on that level. Now, of course, a different consideration for you is, do I want to try to keep these customers happy and have them come back to me, which is a different issue. But as far as from a legal standpoint, the courts take a more narrow view of what your duty is. And so I've cited a New Jersey case which outlined the scope of the duties and responsibilities of a insurance broker to an insured. And the court said the broker is responsible to procure the insurance, to secure a policy that is neither void nor materially deficient, and to provide the coverage he or she undertook to supply. So, in light of that, a more typical case that fits within the scope of a broker's or agent's duty is, and actually, the example I'll give is somebody approached me with this just this week. I asked for an insurance policy to cover my restaurant. And um, instead, what the broker gave me was a policy that only covered weather events. And so that was an issue of whether or not the insured asked for, like a general liability policy, and the broker or agent only gave a weather or facilitated a weather-related policy for the restaurant. Um, as we state in the bullet point below, the line can kind of blur, however, when brokers get more involved. And again, this is the tension that you probably face because you want to be involved with your client and facilitate that business and have them refer people to you and not just minimize what you do for the client. You want to be a good broker as a professional and help them clients out as much as you can. When you do that, however, that's when duties can be imposed on you that go beyond this basic duty, such as if you advise clients or are very involved in the application, or you decide to handle premium notices for the client. And in fact, the law imposes a higher duty once a special relationship is found. That's a term of art in the law, a special relationship. And that's when the broker goes beyond, above and beyond the duties imposed by law. And when that special relationship is formed, the broker agent can be responsible for any negligence that occurs. Next slide. Um,
Uh,
so
let
to,
me let me just add one point, Eric. I think recently I've encountered a few cases in which brokers try to help their clients try to get payout, and that's also a sort of a fertile ground for disputes because sometimes, we have a client who went to their broker, and because a lot of Chinese people, when they got into issues, they just pick up the phone who has to call the people who have helped them get the insurance, which are you guys, right? And the broker told my client, say, "Don't worry, I'm going to call the insurance company. We take care of you, right?" But the agent or broker did not do what she actually promised to do, and then the client failed to respond to a lawsuit, and and then you know everything got went wrong, and statute of limitation, all that kicking, and default judgment, everything kicking. So you all need to be careful if you try to help people. If you promise people to do certain things, you need to make sure that you actually deliver the promise. And if you don't deliver a promise, you need that your client know, because otherwise there are going to be all sorts of potential remedies and course of actions they may assert against you.
so the law is very fact specific.
Hmm.
Uh, One situation can give rise to one result, another situation can give rise to a different result. So I've cherry-picked a couple of issues that I would think would commonly come up for agents and brokers and set forth what the law says about it. And what I mean by when I said that different situations get to different results is that in the law, we deal with individual cases. And when judges decide cases that come to them, they look to past cases. And so a lot of the process is based on finding a case that's like the one that I'm presenting or Lou's presenting, and let's see a similar case in the past and how a judge ruled on that. And so I've picked out a couple of examples of that that, as I said, might commonly come up for you. So one, for instance, is that you don't have to inform the insured about the policy expiration date. The law presumes that the insurance customer should know about that. Um, Another is that you don't have to advise of higher policy limits when it comes time to renew. Here I cited a New Jersey case for that uh, for that principle. So those are a couple of things that you do not have to do. If you do engage with the client about those issues, however, that's when I was speaking, that's when the special relationship can come into play, which I just glossed over on the previous slide. It's an example of going above and beyond that responsibility just to get insurance and taking on other duties. And so in that case, you can be subject to negligence if something goes wrong.
So it's a balancing act. On the one hand, you want to maintain good relationship with your client by sending them notice, hey, your policy is going to expire, right? You need renew your policy now. When you renew your policy, you may consider higher liability limits and all that, right? Although legally you're not required to do neither of those two things, but if you get into the habit of doing, it's kind of a way to get yourself into additional duty and into the land of duty of fiduciaries because you're getting into closer and closer into the so-called special relationship. Is that sort of the right summary of that, Eric?
Right. So if
Okay.
you take on a specific duty year to year, and then
Uh-huh.
it could be informing about the expiration date, for instance, or it could be about adjusting the limits of coverage for someone, and that's something that you repeatedly do. Then
Uh-huh.
the law could impose a duty on you if one year you do not do it, and then something bad occurs, which leads the client to want to make a claim. And
We,
so, as
mhm.
Lou recognized, this is a challenge for you because your clients come to you with all of their questions about insurance, and that puts a lot of responsibility on you, and you don't want to turn them away. But on the other hand, you have to, be cognizant of the extra duties that you can end up taking on.
Yeah, I think the underlying logic of the law is that if you keep doing this, people naturally sort of become dependent upon you and rely upon you, the so-called reliance interest probably. And then if you do not do it, um, people say, I rely on them to do that for me. I think that's the common sense sort of a logic behind this kind of case law and legal principles. Okay, next slide.
Yes.
Okay.
We're back to the special relationship. And this is, by the way, somewhat complex concept in insurance law. A lot of lawyers and judges have difficulty fully understanding it. But I think that the general principles that Lou and I were talking about, is what's important to remember. Um, as this case says, Triarcy, a New Jersey case, special relationship may arise if the customer establishes something more than, I guess we typed than twice, sorry for the typo, more than a broker client relationship. And again, how that is defined is typically the broker just gets insurance for the customer, is an order taker. But what are some scenarios in the case law of when there's a special relationship? It's say if you got additional compensation from the customer to handle various of their affairs, that could, aside from just getting your commission when you sell insurance, that can lead to a special relationship. Or, as we've been discussing, if you give ongoing advice beyond just the procurement of the insurance policy, or if the client can establish in, uh, Lou just used this term, it's a biggie in the legal world, reliance. If the client relies on your expertise over time, and then also if the broker takes on additional duties and responsibilities. So if you start giving legal advice about the insurance policy, then and that legal advice turns out to be incorrect, you could potentially be on the hook for that.
Practice law. That's weird. Um, okay. So essentially, fiduciary duty in common law, it's just the underlying logic is that people with superior professional knowledge than you take you on as just like a lawyer. If we are hired by any of you to represent you, right? Now we are not just sort of mechanically doing whatever um, you know. Whatever narrow contract, right, may require us to do, right? So, Lou, I hire you to conduct this lawsuit on my behalf, right? In that context, we become your fiduciary. We owe you so much more duty than, the four corners of our engagement letter says, because we're your lawyers. But that's sort of maybe a very like legally prescribed set of relationship, right? But what here we're trying to advise you is, you know, to the extent possible, just stick to your rule as an order taker, and be much more cautious when you go above and beyond that responsibility and try to help your client.
So, for instance, if you're going to send an email to your client and respond to a question, give it a little thought. You may want to add at the end of the email, I'm not qualified to give legal advice. You should
Mm-hmm.
contact a lawyer. Or
Mm-hmm.
say, what I'm saying is my opinion based on experience, but it may not be correct. You should always double check your policy language.
Mm-hmm.
Because if those disclaimers aren't in there, then the finger could be pointed directly at you. Whereas if that's in the communication, at least you could say, well, I did say this is just my thought, but you should look at the policy or you should contact a lawyer.
Maybe the same could apply to other things like, yeah, I'm sending you this notice that your policy is going to expire, but it's also your own responsibility to check your own policy, periodically to make sure your payment, everything is not behind. And please do not rely on me to do this for you. Something like that.
Right. So, for instance, I handle a lot of life insurance denials, and you would want to counsel the client, say, if there was a premium notice and the payment was late. There's a lot of denials because people miss their premiums, even just a
Hmm.
couple days before they pass away. That's what happens. Somebody gets sick and they're not thinking about their life insurance. And so, in situations where that happens, you'd want to give them the advice that, you should contact the insurance company and see if you can have a second payee receive notice. So therefore, grandma gets the notice, but the daughter gets a copy of it. So
Hmm.
that duty is not put on you.
Okay. So let's move on to the next slide.
This is another big one. Again, you see a lot of this in the life insurance context. Uh,
Hmm.
with regard to property insurance and auto insurance, not as much. So, for instance, as you probably know, with auto insurance, I think it's called ISO search, that the insurance company automatically does and can pull up somebody's driving record. Although there are garaging misrepresentation cases, where somebody will register the car and insure it in upstate New York because the insurance is a lot cheaper. But then the insurance company finds out after an accident that they lived in New York City where the premium would be higher, and they deny any coverage for the accident. So you do see that in the auto insurance context, misrepresentations about where the automobile is located. But anyway, material misrepresentations a lot of time in life insurance cases, especially considering the amount of money that's at stake and the comprehensive questions on life insurance applications, where they go through your entire history, and certainly all of your medical history. So clients will say, well, the broker did it. The broker is at fault. The broker didn't ask me the question right, or the broker filled out the application for me. So the broker should be the one ultimately paying the death benefit when the life insurance company denies the claim. These are tough claims for life insurance beneficiaries to make, and insureds in other contexts as well, because the courts generally will hold that the insured is bound by their signature. So even if you do fill out the application for them and make a mistake, they are charged with reviewing the application and that their signature is affirming the contents as true.
Okay, that's good to know. Oh, by the way, in about 9 minutes, this meeting will end, and we just need to click the same link and come back again.
Anything you want to add, Lou, before we go to the next one?
Oh no, I'm good. You go on.
I think we could hit the next slide then.
Okay.
Coverage limits. We did review that you don't have an ongoing duty each year to sit down with the customer and say, oh, well, you have a $500,000 limit for your house, and you should raise it to 600,000 because we have tariffs and materials cost more. You don't have to do that, but the law does impose a duty on you with regard to proper and adequate coverage in some situations. Um, like, for instance, this case, Stevens, the agent kind of undertook to estimate the replacement value, and the court said that the agent or broker owed a duty to do that correctly. And again, it doesn't use the word reliance, but this is consistent in my view with what we've been talking about, is that once you undertake to do something, then you can be responsible for it. Um, Here below that is another example, and this kind of harkens back to the restaurant case that came to me last week that I was talking about, where the New York Court of Appeals, which is the highest court in the state, um, addressed a case where a company asked for general liability insurance if there was an accident on the property. And lo and behold, there was an exclusion for employee injuries. And the case was allowed to proceed to trial. I don't know what happened to it ultimately, but it was an example of not getting the right type of insurance. So, in other words, the duty to procure insurance that brokers and agents have, there was a question about whether that was breached by getting a policy with that exclusion for employee injuries. And note that in the decision, the company had asked for that insurance and had evidence of that. So it's very fact specific. Did somebody, in fact, asked for a certain type of insurance that the broker agent did not provide? And is there any evidence of that, or is it just something that the broker is saying after the fact?
I see. So it's especially important that when you try to procure coverage for a client, you kind of toward the end of that project, make sure that you have checked all the, you know, um, asks, all the requests of your client, that you have got the coverage that they are seeking uh, through your representation of them. I see. You ready for next slide?
Next slide. Maybe we'll beat the 6 minutes. We're racing the clock. Uh, Lapse policies and notice duties. And we covered a little bit about this, but sometimes you do receive lapse or warning notices. The premium was missed. It's late. The policy could terminate, will terminate. And again, generally don't have a responsibility to take action. I do have clients who come to me and they say the broker should have told me. And courts just don't reflexively put the blame on the broker or the agent. But are there extenuating facts? And I feel like I'm sounding repetitive by saying this, but did the broker and or agent do things that then imposed additional responsibilities on him or her? Did the broker get involved each time there was a late or missed payment? Did the broker agree to monitor payments? These are all important questions, and that's the raw ingredients that a savvy lawyer will use to try to get liability against a broker or agent, in addition to the insurance company. Okay, next slide. Lessons. So the first bullet point is an important one for you practically because denied claims often lead insureds or beneficiaries to blame brokers. That is true. I do have clients who come to me and they feel like the broker should have done more, or they feel like the broker or agent should have protected them. Again, the law has a very narrow view of what you do, but that's not in accord with reality. And so the law is very out of step in that way. But your customers look to you for more than just getting the insurance. You're a resource for them. And so they feel like you're responsible when something goes wrong. That's not always the case, but they do sometimes, or if not them, then their attorneys look to you. Um, so we have some typical allegations about like the broker failed to disclose health conditions properly in a life insurance policy or failed to alert the client about an impending lapse. But oftentimes, and it's human nature, if an insured did not do something right or forgot to do something or was not entirely honest, they are, it's easy to blame someone else than to take responsibility for their behavior. And so brokers and agents are the first person that they will point to. So it's important to, kind of be a resource to your client, but also protect yourself and be aware that, you could be subject to a claim and to sort of cover your tracks as best as you can.
Next slide.
Yeah. So how to do that? Risk management, use written disclosures and confirmations. I mean, train step not to complete applications for clients. I think it's advisable for the client to do it, him or herself, so that you don't get blamed if there's something misstated. I know it's a common practice for the agent to read the applications questions and to paraphrase them, but it's best to have the client do that. Again, keep evidence of the advice given or declined. And it is a good idea to make it conditional and say, well, you should look at the policy for the final answer. You should contact a lawyer. Um, if you see something that's wrong, however, it's a good idea to say something for the benefit of your customer. Um, it's good to make sure that you have a record of that in case it becomes an issue. And then importantly for you, maintain your E&O coverage and understand its limits. And if there is a basis of a claim to be made against you, um, err on the side of caution and inform your E&O carrier.
We have less than 1 minute.
Yeah, I think this is sort of repetitive of what we just said. I
Yeah.
think we can probably beat the clock.
Okay. All right. So here's the key takeaway.
Uh, these are the biggest lawsuits that I see. The most common lawsuits I see is misrepresentation, lapse policies, and then overstepping the advisory roles. The law is your friend on this, but that doesn't mean you won't be included in a lawsuit. And so good documentation and clear communication remain your best protection. Be there for your clients, but just be smart about it.
Yeah. Also, you probably need a good archiving for your records because sometimes lawsuits will